In an interim application filed before the High Court by Sejusa's lawyers through Mushabe and Munungu Company Advocates, Sejusa's lawyers are seeking for the suspension of their client's trial under military law in the General Court Martial. In their petition, the lawyers want their client released from Luzira prison, arguing that his continued incarceration is unlawful.
And the law says that the High Court is a superior court to the General Court Martial. And if a High Court is handling a case that touches and concerns the very matter which is before the General Court Martial, then the General Court Martial should not proceed with it. That is basically what we are seeking court to determine.
They also want the High Court to expeditiously deliver a verdict on this matter.
Unless and until that particular issue is determined by the High Court, then there is no reason why, and we have told the General Court Martial, there is no reason and there is no basis for charging him as a serving officer when that issue is still pending before the High Court to be determined.
Last year, General David Sejusa petitioned the Civil Division of the High Court, seeking a declaration that he is no longer a serving army officer because he was under the constructive principle dismissed. If the High Court rules in his favor, Sejusa will therefore not be subjected to a trial under military law and could walk scot-free. While addressing journalists at his country home in Rachtura, Chirihura district, President Yoweri Museveni argued that the army establishment cannot retire rogue officers like Sejusa to the public to unleash mayhem. However, Sejusa's lawyers say that this is a contradiction.
Because we are responsible. We are responsible for these people. We are the ones who promoted them. We are the ones who did this. So if somebody is misbehaving, when he's inside a disciplined force and without accountability, so that journalist is talking of impunity.
So there's a contradiction. If some have been discharged because of indiscipline, then the same rule should apply across the board and discharge all indisciplined officers. But I'm not saying that my client is indisciplined, because that is not true. What my client has been since 1995 has been a conscientious objector.
They also contested the president's statement after he revealed that he is not aware of the charges their client is facing.
The president cannot be saying that the chief of defense forces would consult with him on an issue of retirement, but not consult with him on an issue of arresting General Sejusa, who is a four-star general.
General David Sejusa is facing charges related to absence from duty without leave, conduct prejudicial to good order and discipline of the army, participating in political party activities and insubordination. Sejusa faces about 7 years in jail if he is found guilty by the General Court Martial. Suhail Mugavi, NTV Weekend Edition.